So when you file a charge of discrimination with the EEOC, it's always a good idea to get it notarized. I know at the bottom right-hand corner of the EEOC charge, it says that you can just sign it and under perjury, but that's not good enough, especially if filing a charge of discrimination in Texas. The reason for this is that in Texas, you file a charge with the EEOC to get a right to sue letter, or you have to preserve your rights by filing the charge in the first place. But in Texas, there's a loophole for defense lawyers, and that is they can move to dismiss your case if the charge is not notarized. I know it's silly. What's the difference between getting a charge that is signed with a declaration under perjury versus a charge that has a notary? But in Texas, if you're going to file a charge of discrimination, get it notarized. That gives you the option of filing that lawsuit later in state court. If you don't sign it and you file a lawsuit in state court later, it could be a problem because they can move to dismiss your case because you didn't file the charge properly. Now, if you're going to file a lawsuit in federal court, then it's fine. You don't have to get it notarized. You can sign it online or with an electronic signature, or you could just sign it and send it in. But what I'm talking about is filing the lawsuit in state court. There are many advantages in filing it in state court in Texas. In some jurisdictions, you'd rather have your lawsuit heard by a judge in state court than a federal judge. And it kind of depends on where you are. You're going to have to talk to your plaintiff's employment lawyer about that, on which venue is best. But in conclusion, sign your charge before a notary and get it notarized. That gives you the best option. You can file it in state or federal court. Good luck.